our favorite lawyers, Mr. Dale Schafer, who has been around so long that he was around back in the early days and did some time for a cannabis crime and then helped everyone doing time help get rid of their time. That's right, is none other than the Dale Schafer.
Good morning, everybody. My story comes out of Law 360. Headline is Texas Judge Says Pot User Has Constitutional Right to Guns. Now, this has been an issue that's been floating around. I represent Weed for Warriors, and my guys are afraid to even get a state card because they think they're going to lose their gun rights. So this story has multiple parts to it, and we're going to have ongoing discussions. But what I want to start with is that what human beings do, you can't make this stuff up. You really can't. This woman was charged. She was indicted for 2 counts of violating a Gun Control Act from 1968. It seems her husband was next door with a shotgun, shooting and making noise, and he and the neighbor had been smoking crack. And so when the cops showed up, they went to her house and found that she consumed cannabis. Let's use the modern term. She smoked marijuana, and they found a crack pipe and mushrooms. Okay, so what she got indicted for was possessing a gun as an unlawful substance user, and she also got indicted for transferring a gun to an unlawful substance user. And so he was indicted, or she was indicted. They tried to dismiss the indictment. The judge wouldn't do it, but the judge reconsidered when the Texas Appeals Court decided a gun control law that touched upon some of these same subjects. So what they decided was that the Second Amendment covers basically everybody, and that if you want to take away somebody's gun rights, you're going to have to do more than call them an unlaw-abiding person. Let me see what other terms they use. Some of these are hilarious. That they are unvirtuous, not law-abiding, that they're dangerous because they smoke weed. Okay. Now, this law started in 1968, and Rico, you may know this or you may like this, but back in the mid-'60s, the Black Panthers showed up open carrying assault rifles. Okay. And the powers that be in Washington, their butt puckered up real quick, and they went in and they passed a gun control law in 1968. And I was in high school. I didn't care about this, didn't matter to me. And it never really mattered to me. I lost my own gun rights. So as I'm reading this, I remember, okay, this is what they did. And they added so much verbiage in there to capture anybody they could. And the language they use, if you're an illegal substance user or you're a known addict, okay, you can't possess, you can't transfer. Okay. Now, what this court did is it took a look at the New York control or personal carry law that just got struck down by the Supreme Court. Okay. And Jason, you'll appreciate this because the Supreme Court has taken a conservative bent. And what it's decided to do was to overturn the apple cart. Mindy, that's one of my new Daleisms. And what they decided to do was not to look at the New York state law as they traditionally do through strict scrutiny. Okay. What they decided to do is take a historical look at what societies, and particularly the United States, has done with concealed weapons over the history of this country. This is a new version of originalism. What were they doing in 1791 with concealed weapons? Well, a concealed weapon was 3 feet long. They talked about daggers. I read this 135-page case last night, and I thought, holy crap, they're going back to the time of Richard the Lionheart and shit like that. So the dissent from Breyer said, hang on, we have a rule here. If the government's going to do something that infringes upon somebody's constitutional rights, there's got to be a compelling state interest, and the law has to be necessary to achieve the compelling state interest. Well, the compelling state interest is gun violence, and nobody on the court wants that to be an issue. So they invented a whole new standard. So this judge in Texas, and this is a Texas case for Stone, so pay attention to this, took a look at the latest appellate court decision where a guy who had a domestic violence allegations against him, they took his guns away. And they said, no. Domestic violence doesn't make you a dangerous person. Now, I know some women who have the crap beat out of them won't disagree with that, but that's the position the court took. So based upon that, this judge Judge Pantone, I think her name is, she reconsidered and she took a look at the illegal user of drugs and said, no. You have to have due process before you declare someone to fit in that category. You can't just think, oh, gee, someone who smokes weed, you're dangerous, you're non-law abiding, you're unscrupulous, whatever term they tried to use. You have to have a hearing and they have to have an opportunity to be heard before you can take their gun rights away. It doesn't take away all the gun rights, but what it did, it invented a whole new standard for looking at the Second Amendment. Now, is this going to be their course now as they take a look at laws that have traditionally been based upon certain understandings of the Constitution and back up and go, no, in 1791, we saw it this way. This is how we're going to handle it now. I don't know, Jason, but this is something that we are going to talk about because there are many parts to this, a new rule for looking at constitutional rights. And the other part of it, there's a declared statement that smoking weed doesn't make you dangerous and you shouldn't lose your gun rights for that. I want to applaud that. But there's a split amongst now the federal appellate districts. There's one court in Texas that said, no, just smoking weed makes you dangerous and you should lose your gun rights. So this is going to head up to the Supreme Court. We've already got a split. We're going to see it there. So stand by, because some of these themes I'll bring up again as these cases move forward. So there's my take. What do you guys have to say?